Good morning.
Good morning, Your Honors.
Mr. Gurdon?
That's right.
Good morning, Mr. Gurdon.
Good morning. May it please the Court, I represent Joshua Bruner and Richard Bluestein, co-trustees of the Leslie Gould Irrevocable Trust. Mrs. Gould passed away in July 8th of 2007, leaving behind an estate of approximately $40 million. She had created during her lifetime a then revocable trust, which obviously became irrevocable after her death, which included extensive marital deduction provisions. Unfortunately, the formula which divided the trust between the credit shelter share and the marital share was what's referred to as a pecuniary marital deduction share.
Would you agree that the version of the trust discussed in your letter is materially the same as the trust that was subsequently signed by the settlor?
With some minor differences, yes.
What minor differences?
I believe you're referring to the letter of Attorney Breyer from September of 06. I think the differences were that the nephews were given a slightly greater share in the final version than they had been given in the first draft.
But that doesn't change her intent.
No.
And would you sign an affidavit to that effect?
I believe it would.
I do. That would attest to the.
Is that affidavit in the record?
We provided an affidavit we included a copy of the instrument. We included an affidavit as to the authenticity of the instruments.
No.
I'm talking about
I'm
an
sorry.
affidavit as to the settlor's intentions.
In other words, is the version of the trust that's discussed in the letter the same as the version that the testator Leslie signed?
Essentially so.
But
The question here is, can you so inform the court in an appropriate manner, i.e. by affidavit? Answer yes.
Yes.
Would you please do so?
Yes, we will.
Okay.
Could I ask you a question, though, about that? If they are the same, it does seem, and I'm going to get the letter suggests that I think I'm going to get this right. The letter suggests that the effort was to get it into as much as possible into the family.
That's correct.
But there's language, is it in Article 11? 11th of the
Yes.
will that suggests the opposite?
Well, it says funds, if any, in the family trust.
I'm sorry, I'm not. Which?
Okay.
Let's see if I can.
The article
find that.
suggests that there might not be money available for the family trust.
Right.
Well, which of course goes.
And now there isn't. So why is that so contrary to the intent?
That's the question.
When you're drafting an estate planning document, you never know what funds will be available to pass under a trust. It's entirely conceivable that funds will be passing to beneficiaries either directly through a beneficiary designation, through joint ownership, as a beneficiary of an insurance policy, as a beneficiary of a retirement plan, any one of a number of reasons why funds would pass to either a spousal beneficiary or a non-spousal beneficiary that wouldn't pass through the trust. And the formula in these trusts always attempts to adjust for those distributions that occur outside of the trust.
I suppose the question remains, in the circumstances that you've just given, namely there might not be funds for the family trust, in those circumstances, would the funds remain in the marital trust? You're essentially asking us to move from the marital trust to the family trust, correct?
We're asking that the funding formula be reversed to make it a pecuniary family trust rather than a pecuniary marital trust.
Correct. And why would that, if you are contemplating that there will be insufficient or no funds, if any, if any, for the family trust, would you be asking for a reformulation in those circumstances? In other words, if it wasn't the fact that the money had dropped out of the market, the bottom had dropped out of the market?
Well, for instance, Your Honor, if the decedent had a large retirement account, a 401k, an IRA, something like that, and funds were passing to the children and nephews that would otherwise have been the amount that they would have received under the family trust, we wouldn't be asking for reformation because they would have received what the settlor intended. It just so happened that because of the titling of assets, they happened to pass outside of the trust rather than inside the trust. In this particular instance, the bulk of her assets passed into the trust, and it was her intention that of the funds that were passing through her estate and into her trust, that approximately $1 million would be carved out and passed to the children and her 2 children and her 2 nephews. And that is unfortunately what did not occur due to the decline in the market since her death.
You understand that the purpose of these questions is the following. It's very unusual for a court to, as it were, change the terms of a trust. We do it in Massachusetts. Believe me, it's unusual. It's not unusual in Massachusetts, but it's unusual. Mm-hmm. And one of the things we try to make quite sure is, are we in fact carrying out the intentions of the testator? Now, there's no question here, the record is clear, that she was trying to minimize taxes.
Right.
But one way to look at this would be to say she wanted the group of people who were going to benefit, her nephews and nieces and so on, from the family trust to have up to $1 million.
That's
Another way to say it is, if after all of these other things were done, setting up the marital trust, so on and so forth, there was money left over, she wanted to take $1 million of that and give it to her nephews and nieces. It's this latter point that we're trying to understand. What would be some of the other reasons why you would set it up? In other words, this is an unusual way to set it up.
Well, I would suggest, Your Honor, that this is exactly the facts of Reynolds. Reynolds was another case where the credit shelter share was not funded. In the case of Reynolds, it was because of the instrument was not drafted correctly. In this case, it's the accident of the decline in the market.
Yeah, but the accident of the decline of the market raises the question is, let's assume that she thinks she's disposing of, I don't know what she thought she was disposing of, but let's assume it was close to $40 million. Mm-hmm. And now I don't know what the value of, what the actual value is, but let's say of that $40 million, she wanted to give $1 million to her nephews and nieces or whoever was in that family trust.
Right.
But we are trying to figure out what are her intentions when she's only got, what's the approximate value, $5 million or whatever it is?
For Massachusetts purposes, there's a $1 million exemption, and that is clearly what she was trying to put into the family trust. Maybe, but
try to maximize the beneficial tax aspects, regardless of how the tax laws might change in the next several years.
I think her intention was to minimize the overall taxes on her estate and her spouse's estate, which is precisely the goal in Reynolds.
And was that her only intention?
I think her other intention was to make sure that her children and nephews received an immediate benefit. That at the time she executed this, she
and where do we find that?
Well, I think that the facts and circumstances, I think the letter that Attorney Breyer wrote outlining the plan, I think the fact that when this first draft was sent to her, she'd been diagnosed with cancer, she knew she was dying. She in fact died approximately 9 months after the final amendment to the trust. She knew that she wanted, that her husband was likely to survive her by a significant amount of time, and she knew that she wanted to benefit her 2 children and her nephews, and that there were sound tax planning reasons to do so. And I think the outline, the flow chart that Attorney Breyer...
So the question is, why didn't she just designate $1 million to go into it? Why does it have this formula, which may serve other purposes?
Well, the formula...
The tax laws changed in the next year so that $2 million, for instance, was tax exempt, then she wouldn't get the benefit of it. That's the answer to that question.
Not exactly. When this instrument was created and drafted, we all knew that the Massachusetts exemption was $1 million, and it was expected to stay at $1 million. The formula would have taken into account and would have left to the family share a larger amount if the Massachusetts exemption had gone up, but there was nothing there was no indication from the legislature that was going to happen.
Sure. Thank you.
I see.
Mr. Gurdon.
Thank you, Your Honors.
SJC-10652 in Ray Zone